Thank you, Your Honor.
Case number 11, Honeycutt versus J.P. Morgan Chase Bank. The panel for this case is Justice Siegel, Justice Fear, and Justice Stone. Justice Siegel is acting presiding justice.
All right, we have Ms. White remotely. Mr. Warman is here. Ms. White, whenever you're ready.
Sure. Your Honors, may it please the court. This case is about integrity of process and law. 7 years ago, this court, the same division, vacated Patrice Honeycutt's first arbitration award because the arbitrator failed to disclose conflicts with defense counsel. We're back here. This with the same thing had happened again. A new arbitrator, same employer, and the same pattern of undisclosed conflicts. And at this time, the error is compounded. Arbitrator Joseph Pollard, he also disregarded California's anti-discrimination statutes, California Government Code Section 12923, and the Crown Act. Either ground, Your Honors, either lack of disclosure or failure to apply governing law requires vacator under CCP 1286.2, subsections A3, A4, and A6. Now, turning to the statutory framework, clearly under the statute, there's mandatory vacator when an arbitrator fails to disclose a disqualifying relationship of which the arbitrator was then aware, and also when the arbitrator exceeds his or her powers by ignoring substantive law or depriving a party of unwaivable statutory rights. Under CRC Ethics Standards Rule 7F, there's a 10-day continuing duty to disclose new facts, creating a reasonable doubt about impartiality. And then with respect to Government Code Sections 129.23 and 129.26, subsection W, it codifies our harassment standards, clarifying that the court must follow a totality of circumstances analysis in harassment cases, which was not done in the present case. And the reason why that part of it, not really going to I don't want to delve too much into the merits of the case, but when I look at the case and the arbitrator's ruling where he cited to testimony from a branch manager who observed the harassment about Ms. Honeycutt's hair, and there was also testimony about Ms. Honeycutt also speaking to the manager, Zadie Martinez, that took over for Ms. Conti. That is a clear disregard of the law. There were also really inflammatory and offensive instances of Ms. Honeycutt walking into a room and employees talking about slavery, references to her being referred to as ghetto. I hate to use the word B-I-T-C-H, a black B-I-T-C-H, very inflammatory comments. And a reasonable person walking into a room, me being a black woman, there's no question that I would be offended by those types of remarks. But in this case, where you have a manager that is corroborating the conduct, it leaves question of when a party, a claimant, can ever prove a hostile work environment. Because if the trier of fact, being an arbitrator, if he cannot believe a manager, who will he ever believe?
But does that mean that the arbitrator made a mistake, believed the wrong person, applied the law to the facts incorrectly, right? Or does it mean a complete disregard of the law? Because the first category is a mistake, maybe even a bad one. But that's what arbitrators do. They make good or bad decisions, and arbitration is the party's agreement to have the arbitrator decide those. So like mistakes, which arbitrators make all the time. In fact, there's I found one mistake the arbitrator made in this case, which even I would think is a mistake, which I'll ask Mr. Wardman about. But it's just a mistake, and mistakes don't get vacated on arbitration awards because I'm not going to state this correctly, but isn't it pretty much the law in California that we let arbitrators make mistakes and we don't review them?
Well, no, it's not, Your Honor, because it's different where you have a situation where we have a clear law that was codified by our legislature that is binding, that a trier fact must follow. And in this case, the arbitrator clearly knew about the facts. It's not a mistake because he cited the facts in his opinion and award. So
isn't it also the law that, I'm going to mess this up, isn't it also the law that arbitrators don't have to follow the law?
No, they must follow the law. Otherwise, it would turn our rule of law and justice system on its head.
Well, that's a fair criticism of arbitration. That's exactly what people say about arbitration. Well, but I thought that there are case law, and I may be wrong, that says arbitrators should, but they don't have to follow the law. That's not what parties, and I realize whether you agreed to arbitration is a whole other issue, but assuming that the parties did, you agreed to arbitration, you get the decision of an arbitrator, good or bad as it may be, with certain exceptions. And so I guess the question is, does this fall within those exceptions? Well, unwaivable statutory rights, things like that.
If I'm understanding you correctly, I'm not perceiving what happened in this case as a mistake. What happened in this case is a blatant violation of the law where the arbitrator not following it. And if the court were to adopt that standard, everything would be compelled to arbitration. And
that's right.
The side being sued would say, we'll just get into arbitration because we'll get a trier fact that'll disregard our state statutes, and they'll disregard, what our legislature has identified are the rules that must be followed. And
that's why employers like arbitration.
Well, some of them do until they get the bill.
Well, sure. That's true.
But Your Honor, if the court were to adopt that standard, then it would wipe away due process rights to pretty much, everyone, every single one of us. And consumer arbitrations, I believe Your Honor wrote, they must be fair. Your Honor stated that. You wrote a very eloquent decision in Honeycutt Part 1, where you clarified that consumer arbitrations, they might not have to be fair. They couldn't possibly be fair. Your Honor stated that they must be fair. They must.
Certainly, arbitrators, but there's two separate issues. One is you raise whether the arbitrator followed the rules in terms of disclosure, but with respect to the facts of the case, aren't you making the same argument you would make if it was an appeal from a ruling by the trial court, which is a different standard? In other words, you're saying, I don't hear you saying as much that it's a violation that the arbitrator did not follow the law, but your argument is under the evidence that was presented to the arbitrator should have ruled a different way. And the arbitrator listened to the evidence and made a decision that Ms. Honeycutt was terminated because of things she had done and not for the discriminatory reasons. And if we were reviewing a trial court ruling, we would apply a different standard. But it doesn't seem to me it can be that every arbitration decision gets full review for whether the trial court properly reviewed the evidence in terms of making a decision, or you would basically have full review of arbitration decisions.
Well, that's different from this case. And if Your Honors even address the first statutory violation, which is the non-disclosure, Your Honors wouldn't even get to the second basis for
that's right.
Vacator. But as to the one that Your Honor just presented to me, as far as the distinction here, it's where ordinary error is unreviewable. But in this case, there are statutory violations that exceed the powers of an arbitrator, which, under the Ritchie case and Armendariz, the Ritchie case confirmed that vacator is proper when statutory rights are ignored. And here, the Fair Employment and Housing Act, codified in Government Code Section 129.23, and I believe it was 129.26, subsection W, our legislature has made clear. And what we pointed out as to the clear violation was that we weren't even going into the termination aspect of the case. What we were highlighting as to the statutory violation is where there was clear finding by an arbitrator that conduct had occurred with respect to Ms. Honeycutt's hair, where you have a manager who is witnessing that conduct, and the arbitrator disregards the statutory rubric, if you will, and finds that it doesn't rise to the level of a hostile work environment. So I would say that it's not ordinary error in this situation.
Yes, as we've actually gone to 10 minutes, but we have asked a lot of questions. Any points you want to make before we have counsel for the respondent argue, or you still have your rebuttal time?
Yes. So briefly, Your Honors, as far as the statutory framework as to the failure to disclose, we outlined it very extensively. I don't know if Your Honors have any particular questions about it, and I can address those questions. But the essence of it is that Mr. Pollard, he did not disclose his standing with respect to my LAUSD cases. He was making decisions about my clients who, in disability cases, who were separated from LAUSD and adverse employment actions, and not disclosing it simultaneously while he was presiding over the Honeycutt case. Not only was he presiding or involved in my LAUSD cases, but he was also involved in my Kaiser Permanente cases, where his law firm represents the unions, and he was taking a adversarial stance. One would think that a union would be on the side of the employee, but in the cases that I cited, he was being obstructive and taking an adversarial stance in those cases. So those are things that should have been disclosed. Also, if you look at page, I just wrote it in my notes here. He had not disclosed that he was the chair had been the chair of LAUSD Personnel Commission. And that is something that is significant because I believe they're trying to allude that he was only a member. But if you look at 1 EFS, page 372, it is a letter and an annual report of LAUSD where he was signing as the chair. And so if Your Honors have any questions, I can address those in more detail.
All right, thank you. I think we'll hear from Mr. Wortman at this time. A little easier to go around that way. And it does go up and down if you want to adjust the height.
Good afternoon, Your Honors. As this panel is aware, the grounds for vacature of an arbitration decision, an award, are very limited and clearly specified within the Code of Civil Procedure. In this case, appellant appears to argue essentially appears to take issue with two aspects of the arbitration. First, she appears to take issue with either conduct or decisions that arbitrator Paller made during the course of the arbitration itself, and with the decision itself. With regard to, and then secondly, she appears to take issue with the disclosures that arbitrator Paller made, and her argument that further disclosures should have been made in the course of the proceeding. I'd like to start with the first issue, which was the bulk of the argument that we heard about decisions that arbitrator Paller made during the course of the proceeding itself and with regard to the ultimate decision in the matter. There is no question that with regard to the decision itself, arbitrator Paller, after a 21-day hearing and listening to evidence by both claimant and all of the witnesses, made certain factual determinations and prepared a lengthy arbitration decision in which he specified what his analysis was and the reasons for his analysis. Now, I appreciate that appellant disagrees with those decisions, but that disagreement doesn't deny the factual determinations and credibility determinations that were made. In fact, arbitrator Paller made clear what the rationale for some of his reasons were. And when you hear arguments like he ignored what the law says with regard to harassment and a totality of the circumstances test, the evidence in the record quite clearly shows that that is not the case. In fact, arbitrator Paller made credibility determinations about the allegations themselves, said that despite a 21-day hearing, there was no corroboration of the testimony of claimant herself, made determinations about timing issues because most of the allegations regarding harassment were time barred, and arbitrator Paller found that there was no conduct within the statutory period. Those are factual determinations.
Well, that's not quite what he found. He found that Ms. Honeycutt had not shown that they occurred within the period, right?
That there was no evidence to suggest that they occurred during the statutory period. That is correct.
Right. Placing the burden on Ms. Honeycutt. She said that she should have shown there was some within. And that was the mistake, right? It wasn't her burden. It was the defendant's burden because it's the statute of limitations.
Well, Your Honor, there was also evidence that is in the record that establishes quite clearly that the allegations themselves could not have occurred during the statutory period. The three individuals that Ms. Honeycutt alleged...
I'm just saying his ruling was on that issue was legally incorrect because he found that the plaintiff claimant did not meet her burden to show that we're within this limitations period when in fact he should have found, if you were going to rule in your favor on this issue, that you had met your burden to show that that there was nothing within or whatever. Now, that just means it's a legal error, as arbitrators make, and I guess that was my question. Isn't that, or...
Well, as you correctly pointed out, arbitrators can make errors of law. So right. Whether he made one or not is not relevant at this point because there is no because as the Monkarsh decision and other decisions quite clearly specify, arbitrators can make such errors, and that's one of the things that happens in arbitrations and may occur.
It's what you pay for.
Indeed. She also, there was some discussion, and I'm happy to answer questions about arbitrator Paller's conduct during the hearing itself. There was no discussion in the presentation about that, but all of the conduct that was alleged to be wrongful or something. First of all of those things were known to claimant before the decision was made, and no request for disqualification was made. And secondly, all of them are easily explainable by virtue of the simple fact that we were in a Zoom arbitration. There were Arbitrator Paller controlled the arbitration as best he could, and there's really no evidence in the record other than self-serving declarations regarding the conduct itself. I do want to spend a few minutes about discussing the disclosure issues and allegations there as well. I have been with this case for a long time, as has at least two members of this panel. This case is decidedly different and remarkably different from the first Honeycutt decision with regard to disclosures. This is not a case in which there are specified disclosures under Ethical Rule 7 that were violated. There is no evidence and no suggestion that Arbitrator Paller took on any kind of arbitration or took on any kind of assignment or during the course of the arbitration itself. There is no suggestion that there was any relation to the parties. There was in other words, that he was involved in anything related to any of the parties in this case. And there is no question and no suggestion that he received that he had any pecuniary interest in any activity with regard to any party or any party's counsel. The only arguments in this case are that by virtue of the fact that he has a role as on the personnel commission of LAUSD, or that his partner handled some cases for a union in which a union of Kaiser employees where appellant's counsel was counsel for not counsel adverse to that union, but counsel adverse to the Kaiser entities themselves, that somehow by virtue of a 6 degree of separation type analysis, that taints Arbitrator Paller in some way. Indeed, if that's the standard, then just about any arbitration is going to be overturned. In this case, I will make a self-disclosure as we stand here. I'm on the board of the Western Justice Center. One of our panel, Justice Siegel's wife, was also, or I think still is on the board and is leaving the board of the Western Justice Center. I'm not suggesting, nor do I think anyone can reasonably suggest that by virtue of the fact that I am involved in a nonprofit and take voluntary action with some agency, that there is some reason to distrust or question whether there's any bias with regard to any decision that may be made in this case. Similarly, that's the case with Justice Paller, or with Arbitrator Paller. Arbitrator Paller, first of all, there's no evidence in the record that he actually sat in and made a decision when appellant's counsel was even handling a case. The only evidence is that he sat on a commission that involves employees who may at some point have been represented by appellant's counsel in a separate matter, and no evidence that he was even aware of that matter, no evidence that he was a witness, no evidence that he was informed, no evidence that he decided anything, and no reason, even if he had done any of those things, why, by virtue of the fact that there is some knowledge and some connection at some level to appellant's counsel, that somehow he would be biased against her. Moreover, and most importantly, whether he was even aware of appellant's counsel's involvement in the case is unknown, and there is nothing in the record that suggests it. But there is one person who had to be aware of that involvement, and that is appellant's counsel herself, who produced the documents from her own cases, who was aware of the connection, and who failed to ever disclose that connection, and therefore waived any, not only failed to disclose it, but failed to move to disqualify, and therefore waived any right to disqualify. In this case, there's no reason to believe that she was not aware of that connection at the time, or before the decision in this case. There is every reason to, based on the dates of the documents themselves, to understand that she indeed was. One last important item with regard to these issues, and that is the record itself. As this panel knows, there are motions for requests for judicial notice regarding items that were not produced, or not produced is the wrong word, not provided and not in the record in the court below, or were struck by the court below because of the timing, because of the relevance, and because of the lack of relevance to any issue in this case. In light of that, there is no reason why this court should entertain evidence that was rejected by the court below, and no reason for this court to entertain evidence that was never presented to the court below, and no explanation has been given as to why evidence that could have and should have been available at the time of the lower court's decision on the request to vacate and the petition to confirm this award, why there was failure to provide that evidence in a proper and timely way there, and why this court should entertain it instead when the lower court did not.
I have two questions, one procedural, one substantive. Procedurally, did the second arbitrator, was this a AAA arbitration?
This was a AAA arbitration.
Did the second arbitrator know that the first arbitration the arbitration was being done again because of a disclosure issue?
That issue came up in various contexts during the course of the arbitration.
Right?
Yes.
Okay. And I'll address I was going to ask my substance question only if you're going to argue any of that. Do you have anything else on your list you were going to argue?
No, I'm happy to answer any other question.
There's a dispute about whether manifest disregard is the standard or not, the federal standards. My question is, and you may not know the answer, I will confess I do not. The arbitration agreement refers to the FAA, right? The Federal Arbitration Act. Does the arbitration agreement incorporate the federal procedural law or just federal substantive law in the FAA? And the reason why I'm asking is, you can probably guess, does it incorporate the federal standard that y'all are fighting about? Or is it
I don't want to mislead the court. I don't recall one way or the other what the answer to that question is. So I don't want to.
Well, you're ahead of me. I don't even know. You don't recall it, which means you may know, and you've forgotten it. I don't even know what it is.
Yeah, I will say that with regard to that issue, I don't think it matters. And as we discussed in our brief, while we think the correct standard is the California is the CAA rules, and that's what we argued in the brief. Under the manifest disregard standard, we still wouldn't meet the burden. There still wouldn't be anything sufficient.
Right. I just asked because usually when we write an opinion, we say what the standard is and then apply it, unless it's the same, like we do with evidence and summary judgment motion. The standard review is undecided, so we say under either standard, Error or not error?
No. I appreciate the question. I believe that the arbitration agreement it may be in the record, but
it is.
Okay.
But it doesn't. It's a legal question whether.
Oh, but it doesn't specify.
It doesn't specify a procedural or substantive, which leads me to think it's only. If I had to guess, only substantive, but I don't know. And you don't want to say. Fair enough.
I would like to give you a correct answer, but because I don't know, I'll refrain.
No questions here. Anything else?
No.
Thank you very much.
Thank you.
Ms. White, do you have your 5 minutes for rebuttal?
Yes, Your Honor. So I want to address something Mr. Wortman stated concerning something about the arbitrator found that, I'm paraphrasing, that there was no corroboration, but that is an incorrect statement. The arbitrator did find that there was corroboration because a manager, Josie Conti, corroborated what Ms. Honeycutt testified to. And again, my position has always been, if the arbitrator cannot believe a branch manager corroborating the facts, there's no one that the arbitrator theoretically would ever believe. And I kind of jumping all over the place here because counsel brought up an Orvitz versus Schulman issue concerning the continuing duty. And there's no waiver for later arising conflicts. The burden is not on me.
Well, I think he was saying if you know there's a conflict issue, you can't keep it in your back pocket and use it only if the ruling is adverse. Yes, there's a continuing duty, but let's say, for example, one of these cases where you were counsel of record and he was counsel of record, if there was such a case, you would know before this arbitration started that he was on that case. This is hypothetical, right? Even though the arbitrator has continuing duty to disclose it, if you didn't bring it up at the beginning, you would waive that disqualification issue because you knew about it from the beginning.
Well,
I think that was the argument.
Well, I didn't know the aspect of him being a chair of the personnel commission. You know, that's a big deal. And I didn't know that of the extent of his involvement in LAUSD cases or in Kaiser cases, as far as representing UNAC and the various unions that hospital employees are part of, are members of. I mean, I didn't know that. That was, he's supposed to know, you know, what his cases are. Mr. Wortman affirmed that he was aware of prior issues of disclosure. So it's not a matter of claimant or appellant sitting on information. It's a matter of an arbitrator, a very well-paid arbitrator, sitting on the information and being involved in a multitude of different cases. Your Honors, you asked about manifest disregard, and I want to address that because the concept, it is found in CCP 1286 point.
No, actually, it's the federal standard. Right. The state standard is different, but if that's why I asked the last question. If the arbitration agreement, by incorporating the FAA, Federal Arbitration Act, incorporated that standard, then it would apply in your case. I just don't know if it does. Well, and their position is, doesn't matter. We win under any standard.
Well, I don't think so, because he would have to comply with the CCP, and he would have to comply with our legislators' codification regarding the Crown Act and hostile work environments. He can't just turn a blind eye to it and say, you know, I've been paid by this employer, so I'm just going to not adhere to the law or the continuing violations doctrine. You know, I don't believe that the arbitrator can do that. He knew what California law required. He chose to ignore that and apply his own standards, depriving Ms. Honeycutt of her FEHA rights. And not only that, as to the disclosure issues, those are significant. The law is very clear about the Crown Act, hostile work environment, and it expressly rejected Brooks versus City of San Mateo. And the arbitrator should have known about the Crown Act, either knew or should have known. He's required to know what the law is as far as the CH2M Hill case, continuing violations doctrine, which was never addressed. I mean, it's rare that a branch manager would go into a trial, let alone an arbitration, and attest to the very thing that the claimant is complaining about. It's just unheard of. I don't think I've ever seen it in 25 years where a branch manager is affirming the harassment that the plaintiff or the claimant is talking about. Let's see what else here. So I don't know if your honors have any specific questions for me. But the authority is the Ritchie versus AutoNation case.
Well, we know that case. That's the Division 7 case.
Okay.
I believe we were reversed on that one.
Okay. But the distinction between that case and this one is that it was a narrow scope in Ritchie, Your Honor, a narrow scope of review. And the distinction here is that that vacatur is proper when the statutory rights are ignored. So that's the distinction that I see. And then with the Hayworth case, there was no simultaneous litigation where it was overlapping as it was in the LAUSD and the Kaiser cases. And then as to, I believe, respondent cited to a cable connection case, but in that case, that applied to commercial contracts, not mandatory FEHA rights. And then I've already pointed out the Brooks case, which, Brooks, that was explicitly rejected by our legislature under Government Code Section 12923 subsection B, as in boy. So those are some of the distinctions that I see.
All right, we've come to the end of the time you estimated. Is there anything else, any other points you want to make?
The other point, I want to address that the council brought up the Rule 7, the ethics standard, and it's not just limited to relationships with a party or that party's lawyer. It covers any circumstance that could cause a reasonable person to doubt the arbitrator's impartiality. And so when Pollard was deciding Honeycutt, he was simultaneously acting as an employment decision maker for LAUSD cases and the Honeycutt matter. And also involved in the Kaiser cases. And the standard under CRC Ethics Section 7, it requires disclosure whenever the arbitrator or the arbitrator's law firm has a current professional relationship with any lawyer in the arbitration or with a person or entity that could raise a reasonable doubt about impartiality or, impartiality or neutrality. The standard is an objective test. It's not confined to just disclosure in the matter that Mr. Wortman was arguing. Also, So I believe that's
Okay. All right. Thank you very much. Thank you both, counsel, for your argument and for your patience with our questions. The matter will be submitted at this time.
Thank you, Your Honors.
We'll go ahead and hear cases number 9 and 10.